Welcome everybody. My name is Claudia Martin. I'm the co-director of the Academy of Human Rights and Humanitarian Law and a member of the Secretariat of the GQual campaign. I will serve as the moderator of the panel discussion today, titled Current Level of Representations of Women in Human Rights Organs and Mechanisms, Ensuring Gender Parity, a discussion on the report of the Human Rights Advisory Committee. This event is the 10th panel discussion of the Academy on Human Rights and Humanitarian Law's Human Rights Summer 2021 series entitled Experts Speak Series, Addressing Human Rights in Time of Crisis. I want to welcome all the attendees today, and in particular, the students of the LLM program in Human Rights and Humanitarian Law and the participants of the summer program on advanced studies in human rights and humanitarian law who have been following us through this entire series of panels. Also, I would like to thank the organizations that are co-sponsoring the event today, the American Society of International Law's Women in International Law Interest Group, the GQual campaign, and the Institute for African Women in Law. Just as a brief introduction, the panel will discuss the recently published report of the UN Human Rights Council Advisory Committee, which outlines findings on the current levels of representation of women in UN human rights bodies and puts forth recommendations on how to promote and implement gender balance in these organs. I will make sure, probably Adriana can help or my colleagues can help, that we to post the link to the report in the chat so that whoever is attending today can have access should you be interested to learn more about the findings. Next, I'm going to introduce the distinguished panelists who are joining us today. As a background, I want to underline that all the speakers in the panel today had a role in shaping and making sure that the report came to fruition. So thank you very much for being with us today. I'm going to introduce the panelists in the order that they will speak. So I want to welcome Professor Elisabeth Salmon, who is Professor of International Law at the Faculty of Law of the Pontifical Catholic University of Peru. She is also Executive Director of the Institute for Democracy and Human Rights of the same university. Professor Salmon is a consulting expert of the Colombian Special Jurisdiction for Peace and a member, more importantly for this conversation, of the United Nations Human Rights Council Advisory Committee. In that role, Professor Salmon served as the rapporteur of the advisory committee's drafting group, who led the drafting of the report that we will be discussing today. Next, I want to introduce Professor Nienke Grossman, who is Professor of Law and co-director of the Center for International and Comparative Law at the University of Baltimore School of Law, where she teaches civil procedure, international law, and women's human rights. Her scholarship, focusing primarily on international courts and legitimacy and judicial selection and self-representation, is found in top international law publications, including the American Journal of International Law. Professor Grossman was elected to a 3-year term as co-chair of the Women in International Law Interested Group and of the American Society. Thank you for co-sponsoring this event. And very importantly for our discussion today, her scholarship has contributed to shape some of the issues raised in the report. And she's also a strategic advisor to the GQual campaign and has worked with the campaign to advocate for changes on this subject. So welcome, Nienke. Professor Jarpa Dawini is Associate Professor of Political Science at Howard University in Washington, D.C. She's the founding director of the Howard University Center for Women, Gender and Global Leadership, established in 2020. Also, she's the founder and executive director of the nonprofit Institute for African Women in Law. Thank you for co-sponsoring this event today as well. Her primary areas of research include judicial politics, women in the legal professions, gender and the law, international human rights, women's civil society organizing, and democratization. Her scholarship has also contributed greatly to the preparation of the report and the drafting of the report that we will be discussing today. And as the head of the Institute for African Women in Law, she co-convened a regional consultation event with African stakeholders to support the drafting of the report. Viviana Kristesevic is the Executive Director of the Center for Justice and International Law, a civil organization that works throughout the Americas to promote human rights through the use of international law and the Inter-American system for the protection of human rights. In this capacity, she has litigated numerous leading cases on behalf of victims of human rights violations before the Inter-American Commission and Court of Human Rights. Viviana Kristesevic is also a founder and member of the GEQUAL campaign, an initiative to promote gender parity in international representation. I want to underline that GEQUAL was a force behind the report, supporting the drafter of the report through the submission of different views on the issue of gender parity in international representation, and also as a convener and organizer of some of the regional consultations organized to provide views and feedback to the drafters of the report. And last but not least, I want to welcome Elisabeth Snodgrass, who is a partner in the Washington, D.C. office of Three Crowns. She has more than 2 decades of experience as an advocate and advisor, and has been counsel in more than 45 international arbitrations, a mix of commercial and investment-driven matters with a focus on the upstream and energy, power and mining sectors. She has particular expertise handling disputes involving state and state entities and fiscal disputes under long-term contracts. Elisabeth Snodgrass and her team from Three Crowns were crucial in supporting GEQUAL's work in preparing the views and comments submitted during the preparation of the report. So we are very glad that she was able to join us today. After these presentations, welcome everybody. I want to make sure that whoever is following the panel today understands the important role that you have played in making sure that the report came to fruition. Our panel will be organized as a roundtable. I will address a few questions to each of the panelists initially, leaving open the possibility for the other panelists to react, and then Lisa Snodgrass will provide final remarks on the discussion, given the work her firm did, again, as I mentioned, to support GEQUAL in the submission of views to the preparation of the report. And time allowing, we will leave some space for attendees to pose some questions. And if you decide to go through and submit questions, please do it through the Q&A feature that you have at the bottom of the screen. And I will make sure that I leave some space for you to raise your concerns, your questions, your comments, etc. So without much ado, we are going to move forward to ask the questions to our panelists. I will ask first the question to Elisabeth Salmon, who, as I said, was who led the effort to draft this report at the advisory committee. So, Elisabeth, how did the report come to be? Would you like to describe a little bit the process, the structure of the report, anything that you would like us to know about the process?
Thank you, Claudia. I wish to start by expressing my deep gratitude to Professor Claudia Martin and all the persons integrating this panel. In one way or another, each of them inspired the ideals embodied by this mandate and made possible its creation through, for instance, the amazing work done by GEQUAL campaign that led the Mexican permanent mission to generate a resolution from the Human Rights Council that was at the origin of this mandate, and have actively cooperated through research, commenting, and as Claudia mentioned, even organizing regional consultations remotely with the stakeholders from Latin America and Africa to the elaboration of this report on current levels of representation of women in human rights organs and mechanisms ensuring gender balance. Having said this, I must emphasize two additional important points, Claudia. The first one is that this report is also the result of a collaborative work carried out with the inputs and references of the CEDAW committee and the Working Group on Discrimination Against Women and Girls. Both organs sent written comments and were available to hold very fruitful and inspiring meetings for nearly 1.5 years. Secondly, I must add that the methodology of the report was based on a public questionnaire designed by the advisory committee, which allowed us to receive inputs and good practices from a wide range of actors like member states, international and regional organizations, national human rights institutions, civil society, and of course, academic institutions. Regarding the comment, I would like very briefly simply to mention that it considers the current and the historical situation of underrepresentation of women in UN bodies and mechanisms, assesses the impact of this situation, addresses the main challenges for achieving a balanced gender representation, and mentions some good practices and valuable comparative experiences. Finally, it makes recommendations to the Human Rights Council and its organs, to member states, and to the Office of the High Commissioner of Human Rights. Additionally, this report has two valuable annexes regarding gender representation in the human rights systems and good practices from other courts, mechanisms, and comparative experience. I could say that a lesson to be learned from this effort is that we need multi-level and integral work to achieve the essential goal of gender parity, which is both a high ethical goal and a legal obligation. One single actor cannot do the entire job. Thank you, Claudia.
Thank you very much, Elisabeth, for describing the process. I think that the next question should be, what is the relevance of this report, according to your own views, and what is next in terms of the work that the Human Rights Council will carry out and recommendations, etc.
Thank you. I think it is important to highlight that this is the first time that that there is a specific mandate on the subject, and that this report means that now we have an official document in the Human Rights Council. The previous initiatives did not respond to a specific mandate, were not followed up, and were not included in any council resolution. At this moment, this report has been approved by the Human Rights Council's Advisory Committee and is incorporated in the official documentation. Therefore, it can be used by the consultative group for its selection procedures and by civil society seeking to promote the generation of new transparent domestic procedures that include a gender approach. Furthermore, both the CEDAW committee and the Working Group on Discrimination can monitor the follow-up in their periodic encounters with the states, and the issues of the report can be included among the questions for the Universal Periodical Review in the Human Rights Council. I believe that it is important to work in the near future to include the report and in a ad hoc resolution of the Human Rights Council, and also generate some specific guidelines. Secondly, I believe that in spite of several difficulties and backlashes, this is a very promising moment because of the Secretary General's system-wide strategy on gender parity, the role of the High Commissioner and of the Office of the High Commissioner, and even the current decision of the presidency of the Human Rights Council to appoint one ambassador, currently the Angolan ambassador, as a focal point for gender issues. This is an opportunity not to be missed. Maybe I have a few more comments, but I will stop here to listen to the other participants. Claudia, thank you.
Thank you, Elisabeth. And, you will have then the chance to also participate throughout the conversation, giving your feedback on any of the issues that we will be discussing. We are going to move along a little bit to discuss the substance of the report. And of course, if anybody wants to make any comment on the process or, the future, etc., feel free to incorporate that in your presentation. So I wanted to say that The report, I'm going to move on to Professor Grossman, who has written extensively on the issue of legitimacy, and the report concludes that the composition of the UN human rights bodies and mechanisms shows a serious lack of gender parity. So the question to Professor Grossman is, why is parity important? The report justifies the need to address the systemic underrepresentation of women on three bases: legitimacy, respect of the principle of equality and non-discrimination, and the need to incorporate women's perspective into the work of international bodies. Do you agree? So I give you the floor, Professor Grossman.
Okay, first, thank you, Professor Martin, for the opportunity to participate on the panel today. And it's really a pleasure and an honor to be here with all the co-panelists. I know many of you personally, and I wish we could really just be together in the same room again, share a meal, spend some time together. I've learned so much from each of you. And I also, on behalf of the Women in International Law Interest Group of the American Society of International Law, we're so happy to be co-sponsoring this with GQUAL, with the Institute for African Women in Law, and with the American University, Washington College of Law, Academy on Human Rights and Humanitarian Law. Okay, so now getting back to Professor Martin's question. So how to argue for parity? It's actually an interesting question, and it's not what we call a no-brainer. As the report points out, some of these organs and mechanisms are already quite close to this. So, for example, women occupied, as the report points out, over 50% of the seats on 4 treaty bodies. On the remaining 6 bodies, women were 31% of the members. In the special procedures, over half of working group positions were occupied by women, and 42.1% of the individual mandate positions were held by women. Almost 40% of the Human Rights Council Advisory Committee members are women. So some might react to this report by asking, why are we still talking about parity? Can't we all just go home? You know, these are real questions that people can raise in response to some of the good advances, some of the good statistics in the report. So what are some ways that one might react to some of these questions? So first, the picture is less rosy, or even significantly less rosy, when you focus on bodies and positions not explicitly focused on what we call women's and girls' issues. For example, there are many women on the Committee on the Elimination of Discrimination Against Women, but only 2 of 11 country-specific mandates were held by women. For non-explicitly female-oriented positions, the default continues to be the male candidate. Also, it's important to remember that progress is not linear. So for example, the Inter-American Court used to have 3 female judges and now has only 1. Second, as a matter of math, 20%, 30%, and 40% does not equal 50%. In other words, the fact that the numbers have not reached 50% on most bodies means that female candidates continue to be at a disadvantage in nomination and in election procedures. The proposition that there are not enough qualified women to fill these slots is simply not credible anymore. As spelled out in the report, and as I and others have written about, the lack of parity not only raises the specter of discrimination and inequality, which are violations of the rights of individuals and the obligations of states, but also it affects the legitimacy of these bodies in various ways. To me, the most challenging justification for parity is the women's perspective argument. Why do we need to justify the presence of women because of their unique perspective, while men do not need to explain what special corresponding perspective they bring to the table because they are male? Isn't it enough that people bring their own individual knowledge and life experience to the table? Also, is there really a woman's perspective in a world of billions of women of different class, race, religion, ability, sexuality, geographic background, and many other categories of identity? Perhaps there is. The fact that women as a group remain disadvantaged as compared to men when it comes to education, property, choices about their reproductive health, economic power, and many other areas of life. There is still a disadvantage to being born female in many areas of life across the world, if not all of the world. Perhaps what we should do is reframe this argument. The diversity of women should be used to argue for parity rather than against it, as a way of including a wide variety of women with diverse and different life experiences, not just a few token individuals on these bodies. Thank you.
Thank you very much, Ninke, for this very interesting analysis on the issue. I know that you pretty much described the core of the matter, and I'll give the chance later to our co-panelists to make their own arguments if they want to contribute in any way to this debate. But I also wanted to ask you more practical question. Since the report describes good practices from a comparative and international perspective, I wanted to ask if there is anything that we have learned from other international instances, comparative experience that could help improve gender parity at the UN and beyond. I know that you have written on this in your papers, and probably you can give us some of your own views on the matter.
Thank you. So I also look forward to hearing what the co-panelists have to say and their thoughts on all of these issues. So I think Annex 2 does a fabulous job at highlighting the good practices from regional and international courts and mechanisms. And I encourage the audience and those interested in promoting parity to look to Annex 2 for this information. It also looks at arbitration, domestic judiciaries, the public sector, corporate boards. It's great at giving leads to people to think about as they consider ways to achieve parity. Among the most interesting of these mechanisms to me, or practices, are the screening mechanisms for candidates and the aspirations for parity in voting and the requirements. These are all laid out in the report, and there are references especially to the African system, the European system, and the inter-American human rights systems, as well as the International Criminal Court. I don't recall seeing this in the report, but I think it's also a useful reference point. The guidelines provided by the Committee of Ministers of the Council of Europe is extremely useful in laying out best practices for outreach and screening of candidates at the national level. So that's, I think, a particularly good practice that people might be interested in. Another important and interesting point is the role that NGOs have played in pushing for gender parity in international bodies. And, you know, even with Professor Martin's introductory remarks about the role of GQUAL and helping to get this on the agenda, and there's so much to learn here about the role of NGOs. GQUAL has also been pivotal in getting the OAS General Assembly to pass resolutions involving the need for gender equity and balanced geographic and legal system representation in the inter-American system. Within the International Criminal Court, there have been several NGOs that have been pushing since before the ICC was created until now on achieving gender parity and other kinds of diversity on these bodies. And there are similar initiatives in the arbitration world as well. So I do think that we could take a closer look at the role of NGOs in pushing here for change. So I think that's all I have to say about that for now, but thank you again to everyone, and I look forward to the discussion.
Thank you, Ninke. I want to give anybody the chance to comment on the issue of gender parity? Why gender parity? Is it a question of women perspective, legitimacy, equality and non-discrimination? Anybody who would like to add to this? Really? Okay, Viviana, go ahead.
I actually love the argument of rights. So I think, and maybe I'm a lawyer, I'm a litigant, but I work with judges and I work with policymakers. And I think that beyond, I know, some of the goals that we can craft through, referring to the Sustainable Development Goals and why equality is good. And I think that there's a lot of power in saying that parity and equality are rights, and fleshing out those arguments. And I think that has been wonderful from the process of doing this report and throughout the campaign, in just trying to understand how could we give a more meaningful and deeper understanding to concepts of equality. And I think I love what Elisabeth did with the report in including some of that information, and also encouraging civil society and others and governments to report to the working group and to the CEDAW committee based on other arguments on access to justice and equal representation at the international level, and political representation as parts of women's equality, and the reasons why women should be part of the conversation. So that's my little contribution to the conversation.
Anybody else? You want
I
to?
have a question for Viviana, actually.
Okay, go ahead.
Viviana, do you think that states are convinced by the rights language? I mean, in light of the fact that, you know, there's such a backlash going on against even the sort of human rights rhetoric. As the founder of, you know, of GQual and being involved in this in relation to states and how you convince them, is it convincing to them to use the rights language?
I do believe that states have multiple actors, and part of the changes will come from the judiciary. And I think that the rights language empowers people within the executive. I think we have discovered with the campaign, because I represent victims, and so I'm not always in the most cooperative, sweet conversation with states. But throughout the campaign, I've seen in practice how many policymakers and people within the executive have actually used the legal arguments and the rights arguments to pursue their own equality goals internally. So yes, I do believe that it's powerful from a policy perspective. I think it helps within the executive, and I think for sure it gives additional tools for the ombudsman's offices. It gives additional tools to the constitutional courts, and obviously to civil society. So thank you. And I actually love this idea of transformational equality, transformative equality, like distinguishing these 3 different types of equality that is captured by Elisabeth's report. I thought that was really valuable.
Thank you. I'm going to give the chance to Jorpa if she wants to add anything to this. I know that she has written a lot about it, and I don't know if you want to refer in any way to the question or even the issue of legitimacy. But I'm going to move on and ask you the question, and then you can also respond to this debate if you have an interest. The report identifies, I think this is one of the most important contributions of the report, identifies domestic and international selection procedures as obstacles for the appointment of women in human rights treaty bodies and mechanisms. So I want to ask you if there's something compelling or particularly compelling about human rights organs and mechanisms as opposed to other international bodies. Should we distinguish? Should this mechanism be different in terms of ensuring gender parity? If we think about what Ninke said about having the women perspective, this is more important here than in other international bodies. Is it the same? I don't know, what are your views on the matter?
Okay, well, thank you very much, Professor Martin. I would like to start off thanking all the participants for joining us today, and to thank Professor Elisabeth Salmon, who really started this discussion, wrote the report, and engaged with the Institute for African Women in Law. It was a great collaboration. I also really want to commend GQual for the work you've been doing. The Institute has been a partner with GQual. We've attended conferences with you. Under GQual, I made a public submission to the then Vice President of Tanzania, who is now the current President of Tanzania, and she signed the GQual campaign in 2018 in Arusha. So GQual, thank you for the work you're doing in getting women onto international courts and tribunals. And of course, to my colleagues here who, Ninke has been my go-to reference person when I'm working on this. And so thank you all really for this. And last but not the least, I want to thank all the people who came to the Institute's collaborative high-level meeting with Professor Salmon. There were judges, former judges, current judges across the continent of Africa. There were diplomats, there were academics who took time to contribute. So Judge Izoako from Nigeria, Judge Mugenyi from Uganda, Judge Nahamia also from Uganda, and the mechanism. So thank you all for your time. So with all those protocols observed, I also would like to encourage all the participants that please read the report. It is great, it is wonderful, it is rich in data. I am not a data person. I'm not going to throw the numbers, but I encourage you, there are lots of percentages in there that you should be taking into account. So with that said, that links me back to what Professor Grossman said, that if you look at the numbers in a whole perspective, it looks great, 40%, let's go home. But no, if you disaggregate the data and you break it down further, you realize that the numbers are not very good. So now to answer the question, Professor Martin, and maybe I was trying not to talk earlier on because I knew it would be my turn soon. And maybe building my response on what Viviana said, should we have a valid reason? I would say, yeah, the simple reason, it is the right thing to do. Now, I know that lots of people have different definitions of rights, so that could also lead us into a whole discussion, but it's a simple thing, it's the right thing to do, not for women, but for humanity. So if we are approaching it from that perspective, and to answer the question you posed to me, Professor Martin, should the human rights bodies be different? I would say that if we are operating really from a human rights perspective, from an international law perspective, under the principle of equality, it should be the same, whether it's a human rights mechanisms, international courts, international tribunals, or international organizations like the UN or the World Bank. It should be the same standard. We should all seek to promote equality, gender equality, and other forms of equality. However, if I step back a bit from that general norm of equality that we should all be fighting for as enshrined under the UN Charter itself, and look specifically at the human rights mechanism, I would think that there's a level of a higher obligation, maybe, on these human rights bodies. Because what are they? They're human rights. They're really special bodies, I think, set up to protect human rights, to enforce these human rights in different ways. So there's that level of extra requirement that we should place on them in terms of making sure that we do have equality and they push for it. So going back to this report that's been produced by and led by Professor Salmon, it's great because you would think that the place where we could have found equality for all would be within the UN system, or specifically within the human rights bodies. But the data show us that that's not the case. So in a nutshell, yes, there should be that general requirement for equality. The human rights bodies mechanism should have a little bit of work to do Because if they cannot set the standards right, if they cannot lead by example, then how are we going to be able to push other organs outside of the human rights system to do the things that we're telling them to do? Also, beyond the human rights mechanisms, it's also the UN. The UN, as we know, is an international body, and it has a big diversity problem. It's been documented, the data exists. So if the UN is telling the world, MDGs, SDGs, what's going to come after SDGs, I don't know. If they are not leading by example, then how do we expect states, going back to Viviana's point, how do we expect states to enforce these human rights, equality norms, gender norms that the UN itself is not doing? So I'll end up by saying that at least I think progress is being made in terms of the numbers are growing in some spaces and not other spaces. The current UN Secretary General Antonio Guterres is very much focused on gender equality. So hopefully that will trickle down to the rest of the UN and to human rights bodies.
Thank you, Jarp. I also wanted to ask you, because of your expertise in Africa, since this report refers to underrepresentation of women at the UN human rights bodies and mechanisms, I wanted to ask you if there are different experiences at the regional level, if the challenges, if you believe that the challenges are the same in the regional, different regional systems. And then, of course, I will circle back to Viviana, who has extensive experience in the Inter-American system, on Link, if she wants to add anything on that. But I'll post the question to you.
Thank you for that follow-up question. Okay, thanks for that follow-up question. So I'll make it quick, and I'll say this, that I like to look back just to kind of really show that all that we are saying are really interconnected. Professor Salmon said this is not something to be achieved by one person or one body or one state. It's a collective effort. Now, Professor Grossman also mentioned that in the diversity of women around the world, yes, women may have certain common identifying things going on, but we're also very different. So in the same way, states that consists of human beings, including women, are also very different, as we know it. So as we know, within the human rights system, some states will look at equality or global human rights as culturally relative, and therefore pull back if it's to their interests. But if it's not, then they have other arguments that they can advance. So are there differences? Absolutely. The world is made up of different geographic regions. Now, I study the African region. And once again, let me say that Africa is a continent, so I don't hold claim to knowing everything about a continent and its peoples. But based on what I know, history, the studies I have done, that even within the African continent, there's wide diversity in the 5 geographic regions within the continent. So if I were to break down each of these 5 geographic regions, you will find out that the diversity in terms of where women are coming from, going to international courts or tribunals differ. So what has been done at the regional level within the African system? The African Union has established laws that seek to promote and advance women. Now, most of us here might know the special protocol within Africa called the Women's Rights Protocol, Maputo Protocol, which was passed and really aggressive in terms of seeking to advance women's rights. Now, some success have been made, but there's still a lot to be done. But in terms specifically of getting women onto international bodies, international organizations, we find out that pulling from the Maputo Protocol, Article 9 on women's access to international organizations or leadership roles, and also, as was mentioned earlier by Professor Salmon, important role played by women's civil society organizations. The African continent has strong and powerful women's movements. And so they have also been able to use the system created by the Maputo Protocol to advance women's rights in different places. Now, in terms of women international organizations and international courts, I wouldn't say that we necessarily have had a strong movement in that area, but that links us to the point that if you seek them, you will find them. Across the African continent, there are women who are equally qualified, and I would dare say sometimes more qualified than their male contestants. And so if we seek them, we will find them. And I think that the same can be said for other regions of the world. If we seek the qualified women, we'll find them. Let me end on this note that I personally dislike using the word using the word qualified when I'm talking about women. we should just say women, because you would often just say men candidates, but with women, we say qualified women candidates. So presupposing that we have to already add something to it. And so it should end up on this, that the regional differences, I think the report does a good job of showing the regional diversities to some extent. But even if I am not going to be talking about the whole continent of Africa, I don't want to lay claim to all of the world, but there are differences in terms of, one, which states are nominating, which states, which regions of the world have transparency mechanisms, which regions of the world have different cultural norms that may affect women differently than others. And so all these have to be taken into account. Let me end on this note. Most often, people will not think that the African continent would have produced the most women on these bodies. But looking at international courts and tribunals, at the ICC, Africa region has had the highest number of women on that court, as compared to Europe, which has had the lowest number of women. If you look at the ICJ, the continent of Africa has placed one woman there, which is not enough, but if you consider the four, we've done great. The African Human Rights Court on Human Rights has the highest number of women in any court. So with all that being said, challenges still remain. We can learn from regional bodies, regional parts of the world, what needs to be done in order to make sure that there's regional learning from places where success has been achieved.
Thank you, Jarpa. I don't know if Viviana or Ninke, if you want to add anything to the regional challenges, comparisons, etc. You have followed this discussion closely as well. Viviana, you want to?
Okay, I can say that in disaggregating the numbers and the subregions within the Americas, we've seen that continental Latin America is by far the most underrepresented group of women worldwide, which is very counterintuitive because we've had so many, we had a group of women presidents in several of our countries. And we have, in some countries, we have laws that include quotas for the legislative power. So sometimes you see women in the national courts, and you see them in politics and in the cabinets, but they don't get to some of the, well, generally they don't get to the higher courts of the region, neither they do get into international bodies of justice. And as much as we can say that we know, there's a lot that we don't know. And I think that there's a lot to explore and to understand individually and collectively. We've tried to address some of these problems nationally and internationally through different processes, and encouraging a group of experts to do a report to qualify to do a screening of the candidates of the Inter-American Commission and the Inter-American Court, and Ninke and Elisabeth have participated, for example, of those efforts. We've promoted with different law associations and law schools and human rights organizations, discussions at the local level with diplomats and policymakers. And in some countries, we've made some progress, but it is truly shocking, that situation. And then, I think the numbers are completely counterintuitive, and also the explanations for the numbers are not so clear. And so I do believe that the report gives us a lot of tools to work on some of those levels of underrepresentation, but I also think that there's a need for in-depth scholarship on this issue.
Thank you, Viviana. Before moving to asking you some questions, I don't know if Ninke or Elisa want to add anything to the process. They were, in fact, members of the expert panel assessing the qualifications of candidates before the commission and court at different times. So I don't know if you want to give any views on the matter, particularly within this region.
Yes, Claudia. Sorry, just 1 minute to say that I totally agree with Viviana, with Ninke, with Jarpa. I think that there has been some procedures which have helped a little bit to professionalize and insulate the other systems of human rights that from sabotage appointees, we need more procedures, I think, in the Inter-American system. There are some tools, some experiences lived in other continents, strong enough to protect the system from political views, from chronisms, from particular interests. And I think that we need to build that. The screening committees, for instance, to fight against opacity, to fight against that only the executive branch has the last word in doing these national procedures. And well, I don't want to monopolize because there has been a lot of recommendations in the report. But I think that there is some research that we need to do to understand very well exactly why in our system, when we have brilliant women, we have still this problem. We have an Inter-American court which is ashamed to have 6 men and just 1 woman there. It's 1 woman there. I think we cannot. It doesn't resist any rational approach to that problem. Thank you.
Ninke?
Yeah, I mean, I would just add, I think this basically builds upon Viviana and Elisabeth's comments, but I think looking at Latin America in particular, the 3 things that come to mind for me are lack of transparency, lack of process, and lack of political will. So people, there's not clarity about, you know, when people are being selected by whom for what positions. There's certainly no outreach to try to encourage people. As a general matter, there may be some, you know, limited exceptions to that. And then, you know, knowledge about process. What's the procedure here? Sometimes people don't want to put themselves into the running for something when they think that there's really no process. So it's already predetermined, they know who they're going to go with, you know. When that's your perception of the process, then is it really worth it to you to risk it? I think that may, you know, have something to do with it. And then the lack of political will. I mean, I think that there are a lot of people who still don't buy the parity arguments, who still don't think it's important. I remember speaking at one point with an ambassador from a country that shall remain unnamed that said to me, you know, we need a serious candidate, so we're going with the male candidate. So, you know, there's still, and I've heard comments like that also from judges on international courts, you know, saying, why do we need women on this court when our, you know, subject matter jurisdiction is not about women? So I still think there's a serious lack of political will. People are not convinced about this. Many people are not. So I think all of those things continue, unfortunately, to be obstacles. Thank you.
Thank you, Ninke. I think that it connects very well to the questions that I have for Viviana, because in some ways, what you have described is reflected in the report. And so I wanted to ask Viviana, what are the key findings and recommendations of the report, things that should be highlighted in terms of understanding obstacles and also trying to look for measures to address the underrepresentation of women in international courts and tribunals. And then if you can complement, what was the role of GICWAL in this process, since we all know that as I said, it was a force behind pushing for the issue and also helping with submissions for the drafting of the report. Viviana?
Thank you for the question. And I will encourage everybody to read the report. I think Elisabeth did a wonderful job in thinking it through and making it go one step forward. As Jarpa said, you have to read it, because I'm going to do like I'm going to try to summarize parts of the report. We all have our favorite tools. I think if we understand change as something that will happen from our collective efforts at different levels and from different stakeholders, you will all for sure find something that will be interesting and challenging from whatever you are. If you're an academic, if you're a policymaker, if you're a judge, it's really, truly remarkable. That's what I love the most about the report. It not only calls for not only highlights the underrepresentation of women that exists and explains why it is important and what are the benefits of having gender balance in these spaces, but it also gives you very practical tools to move the discussion forward and to change the picture, as we say in the campaign. And you can see from the treaty bodies at the UN and the special procedures, the mechanisms, the working groups, the special rapporteurs, the report goes through the treaty bodies procedures and the special procedures, and it shows what things are wrong at the national, at the international level. Some things we already know about the lack of formal and transparent and public processes, but the report underscores the need to have gender parity or gender balance as a priority and as a goal, because as Ninke said, progress is not linear, and if you don't take it into account, you're not going to be able to sustain it. Gender parity, justice, rights are part of backs and forths and tensions. So it's not that we achieved gender parity and here we are. No, we've been going back and forth with several of the organs, as shown by the Inter-American Court, but also by the Committee on Persons with Disabilities. So I think this idea of having it as a central objective is critical. And the dissemination of information and what everybody can do to disseminate information about the process, about the positions that are open is critical, about breaking the stereotypes and the gender roles and the practical problems that oftentimes women in different situations and conditions face when trying to access those jobs. What am I going to do with my other job? What am I going to do with my family situation, whatever it takes, like taking care of, all the caring that we generally do horizontally to the elders and the younger. So how does the international system as well adjust to be welcoming to women, and what are the systems that can be put in place? When we're talking about these positions, we're just talking about 500 position tops, 500 in the whole wide world. So in the GQual campaign, we follow around 600 positions. So it's 300 women that you need in order to achieve equality at this level. So the report goes through the lack of treaties, of not including gender criteria as a goal, but also not having processes, statutes, or mechanisms for ensuring that the voting will result in gender parity or in gender balance. And for the special procedures, there are several issues that are highlighted, including they need to distribute information, they need to ensure that the consultative group, which is one piece of the path to the selection of the members of the special procedures, takes into account gender and gender balance, and that there are specific guidelines that are in place for that group. And then the report is really smart in going in doing specific recommendations for the Human Rights Council and its bodies, and for states, and for the Office of the High Commissioner for Human Rights. And it gives specific tools for each of them. So, for example, and just a few, it's like when we're thinking about treaties, new treaties, or reforming the statutes or directives for the selection or the nomination or the designation of members for different types of monitoring bodies or treaty bodies or courts, we should have considerations about gender parity and ensuring that that is secured or guaranteed by the process itself. That is pretty revolutionary in my book. Ensuring that there are measures to identify candidates, and then there are specific recommendations about processes at the national level, which are really important and necessary to make to make progress happen. And also accountability, this idea of monitoring and reporting and informing, how much progress have you made, and are these goals that you have, getting you to the place where you really want to be. And I think that the Office of the High Commissioner for Human Rights could also do a lot in that respect, disseminating information and talking to states, giving them advice on these issues at the national level and at the international level, helping in the process of drafting treaties and statutes, engaging more actively with different types of organs and with civil society domestically. So I will leave it there because you really need to read it and and find what are the tools that and the discussions that will move you and will help us all collectively achieve what we really want, which is an international justice that looks more fair and that reflects the gender parity and the diversity that we have worldwide. And the GQual campaign, I think, has been important in these processes because having the numbers of underrepresentation before every selection of a rapporteur and a working group and a treaty body, and having that discussion, that informed discussion going, has helped a group of people, a very broad group of people, keep that debate present, and it has created synergies with other really very valuable processes, but that have also very specific goals. So, for example, with a system-wide strategy on gender parity of the UN is inward facing. So it's about the management and the different institutions within the UN. But the GQual campaign has been focusing, and I think this report makes it so much better for all of us, in some places that are not of the resort of the Secretary General and the UN bureaucracy. It depends on states and states' goodwill and commitment to what they are preaching in terms of parity and representation, and the campaign has helped put an emphasis and underscore that outward facing space and bodies are very important as well for the legitimacy of those bodies, and also for the UN as a whole. And more practically, as it was mentioned before, we talked to several governments and we did advocacy before the Human Rights Council, and wrote reports and letters and thousands of little letters. And then when we were lucky enough that the resolution of the Human Rights Council passed with the support of the Mexican mission before the UN, we engaged very closely as well with them, and then with Elisabeth as the lead person in the process. But we had been working already with a working group on discrimination of women in law and practice, and with the CEDAW committee in bringing this issue and bringing them not only the factual information, but systematizing some of their own work and legal scholarship so that they could put it in their agenda. They have a lot of demands. So the work that we can do from academia and from civil society is critical, and from law firms, obviously, is critical, so that they have the possibility of having that wealth of information systematized, and then they can move forward in developing their recommendations. And then we worked closely with several of you, with Claudia and Jarpa and others in convening the meetings with African scholars and judges and practitioners and people also from the Americas in order to help Elisabeth with inputs from a variety of women and different experts that had been thinking or living through the processes of being nominated or elected or not elected, or looking at or litigating before these bodies. And so
Viviana, I wanted also to ask you a little bit about the where you see the recommendations going, and this is connected because we have a few questions about it. And I think that Ninke said that in her presentation, in her answering to the questions, some progress have been made. We have to acknowledge that, but the progress is not linear. So it requires to do more to sustain it. So the question to you is, how do we ensure that these recommendations are implemented, that the states own the recommendations? There is a movement towards addressing the obstacles and ensuring that more women get to these positions. If you have any ideas that you could give us some of your, I know that you have been thinking about this for a long time.
I think that we have to take stock of what we achieved during these 5 years of trying to make sure that this is an issue and that is taken up on by different bodies and spaces, and I see it with the composition of the Inter-American Commission on Human Rights and the discussions around the composition of the Inter-American Court on Human Rights, that was never an issue before. And now the debate itself is refreshing and encouraging. I think the same happened with the Committee of Persons with Disabilities. They went from parity to one woman to parity again. So, and we contributed along with the very vibrant and fantastic civil society that has been working on issues of persons with disabilities on that, and with many of the special rapporteurships with this amazing report and the resolutions of the OAS, I think that the secret for our success of this past 5 years is what is going to be at least a starting point of what comes ahead. And I think it's perseverance, collegiality, working with different stakeholders at different levels, relentless discussions about what we can do in different spaces, bringing those discussions nationally and to the different corners where it has to create a different type of policies and practices. And I think that the report itself, and I value it enormously, will give us that tool, that if we discuss it, if we work with it with the different stakeholders that are critical for change, we could actually make it. I think that in 5 years, we could actually be much closer to our goal, not to ending inequality and discrimination, but I think at least to making significant progress in this area. And I think that this area is so consequential. It shapes our world, it shapes our future. It talks about who we want to be as a world, and what is the face that justice and rights have to have, that is a worthwhile endeavor. And so for all of that, I thank you all. And I specifically thank Elisabeth for her leadership on all of this. And also I want to thank Liz, who I haven't worked with very closely, but Three Crowns was critical as well in helping systematize and think through and putting their bright legal minds and advocacy skills towards ensuring that this report was possible. So.
Thank you, Viviana. Now that we were thanking Liz, I want to, I will leave the last few minutes for everybody to answer any questions that you have, any comments that you have when we ask the questions about, the future, the recommendations. Please keep your ideas, and I'll be happy to give you the floor to make some comments on that and complement what Viviana said. But I want to give the floor to Liz because of the support that they provided to the preparation of the report, and to give us her views on this matter. She comes from practice, and of course she has been also keeping an eye on the issue of gender parity from her own experience. So Liz, I give you the floor to make your final remarks.
Thank you so much, Professor Martin, for the invitation to join the panel. Sorry, to get the camera pointing in the right direction. And also for the invitation to be involved in this important initiative. We were really delighted at Three Crowns to be able to play a supporting role in helping to play our small part in bringing the report together. So I had the honor of being the official leader of the Three Crowns team that did provide that support, but that sentence really does, aggrandize my role a great deal. There was a whole team here of people who I should just mention, in particular, Penny Martin, who is a senior colleague of mine, a counsel here who has written extensively on the issue of gender representation in international courts and tribunals, who really was the intellectual firepower, the thought leader on our team. So she should be here today instead of me. So I just wanted to name check Penny as somebody who really was a leader on our team, and my colleagues as well, Raimundo Treves and Laura Pereira, who really did the hard work. But it's been a delightful experience. So thanks very much for involving us and for giving me a chance to join this conversation. So there's the perspective that I bring to this, in addition to having worked along with GQUIL on supporting the report process, is as an international arbitration specialist, having worked for some 20 years, appearing before what I will describe as systematically ungender representative, ungender parity arbitral tribunals that are sometimes described in a phrase that I think threatens to sound a bit mean-spirited, as pale, white, stale, old, and male. So that is the typical arbitral tribunal. Certainly when I started practicing 20 some years ago, was 3 white men of a certain age. And as long as I have been practicing in international arbitration, that dynamic has been the subject of debate and challenge and controversy and efforts to bring change. And so there have been numerous panels, just like the one you all have convened around this report, to talk about how do we address this issue. And so today's discussion brings for me a strong sense of deja vu, right? We are all focused on the same set of dynamics, addressing some of the same issues with some of the same tools, and some different ones. The reality in the international arbitration context is that despite 20 some years, more than 20 years, 2 generations of debate and calls to action and pledges to take action, we really haven't moved as far, even actually as the numbers show the UN system has, towards gender parity on international arbitration tribunals. Just to give you an indication, some of the statistics show that international arbitral tribunals, which are chosen typically by the parties to international arbitral disputes, tend to have a representation rate in terms of women on those tribunals. The statistics compiled by a report that was pulled together by I'm going to get this wrong, the International Congress on Commercial Arbitration, ICA, last year found that in 2015, across arbitrations handled by 10 different arbitral institutions, there were 12% female arbitrators. And 5 years later, in 2019, there were 21% female arbitrators. So a little bit of progress, but nowhere near parity. So in a lot of ways in arbitration, we are further off than the UN system is even. And so as you can imagine, there's a considerable debate. And the one thing that I learned in learning about the UN system and thinking about how and helping take the inputs that you all received about many brilliant ideas about how the UN system might move the dial towards parity in its mechanisms and institutions is really just to be struck by the extent to which the UN system has the advantage of having a framework of rights to invoke that is really not present in the international arbitration system in a direct way. Right, so international arbitration is a creature of party consent. The parties get to choose their arbitrator, and although they can't, they oughtn't to actively discriminate. It is a free choice. Parties may choose who they prefer, and so it's much harder to police. And there isn't a framework of saying you, the institution, or you, the party, have signed up to a suite of commitments, human rights commitments or otherwise. And so I think the tool that the UN system has, the tools that the UN system has, already having stated commitments to equality, the rights dialogue, Viviana, that you were referring to is so powerful, seems to me to be one feature of the UN system that really is a powerful advocacy tool and a powerful rhetorical tool for talking around gender parity in the UN framework, just as an observer of the system, because that's something that when we talk about gender representation in arbitration, we can talk about equality as a sort of in the water consensus, surely everybody agrees it is the right thing, but we don't have what the UN system has, which is a set of written commitments, a set of signed, sealed, and delivered commitments that you can point to and say, look, hey, we are in fact a human rights organization. Hey, we are in fact focused on pursuing human rights objectives, and I think that's a really powerful tool that the UN system has to continue the progress it has made, albeit sometimes with 1 step forward and 2 steps back, or 2 steps forward and 1 step back towards gender parity in its institution. Another reflection on the conversations that you were having today is around this question of qualification, right? And what makes somebody a qualified woman or a qualified member of an institution or a qualified arbitrator. And I think that's been, there has been a lot of concern and rightful concern to ensure that in delivering a dispute resolution service, which is fundamentally what international arbitration is, we are not asking those clients who are choosing arbitration as the method of resolving their disputes to accept a lower quality service, to trade quality for equality, right? And so there's been a lot of care devoted to ensuring that we aren't, prioritizing getting the numbers right, getting balance, getting parity at the expense of making sure we have an adequate number of experienced, qualified female candidates. I'm happy to report that I think certainly over what feels like a lifetime, 20 years of my career, I think the debate around are there enough women has sort of definitively been, that argument doesn't wash anymore in international arbitration circles. There are, and I think the suggestion that you can't think of a qualified woman now reflects, certainly in the circles I practice in, reflects very poorly on a professional who can't think of one, right? I think now international lawyers of my ilk consider it their responsibility to know, right? My responsibility to know diverse candidates. And if I don't, it's because I haven't done my job, not because they're not out there. And I think that really embedding that understanding and really operationalizing that understanding and taking the opportunities to find, now moving beyond gender to saying, well, maybe I don't really know that many practitioners from Africa, or maybe I don't know that many practitioners from Southeast Asia, and I need to get on that, right? I practice in an international dispute resolution space. That's my responsibility. I need to be able to advise my clients how to find diverse decision makers, right? And I think that's the next phase. Not that we're done with the previous phase. We're still not getting there in terms of results, in terms of getting, getting representation on tribunals. But it's not enough to say, there aren't enough. There are plenty. And it really is the job of professionals who are advising clients to be able to link those clients to those diverse professionals. And I think it's internalizing that and finding ways of doing that. And it's events like this, it's teaching in international universities and programs, and just knowing people, knowing people who do the things that you do, and knowing people who have skills that are relevant to the disputes that your clients are going to be confronting is really, has to be seen as the job of a 21st century international disputes lawyer. And I think we're slowly, very slowly getting there. So that's around the debate around qualification and are there enough. I think on women, I think no one will say that to you anymore. I think on other aspects of diversity, we're still a long way off, sadly, in arbitration. The other thing that I will say, though, about diversity in international arbitration, I still think we're a little bit stuck on, we're not even yet really aiming for parity. We're still kind of aiming just for representation, right? So there's still a little bit of a sense that one's enough, right? You typically have a tribunal of 3 arbitrators, and there's kind of a sense that, well, as long as you've got one who isn't like everybody else, then you've sort of, you've done your job. And I think, we had a debate in my firm about a policy towards trying to challenge ourselves to do better, trying to challenge ourselves to appoint more diverse panels of arbitrators and suggest more diverse candidates. And we were thinking specifically about gender. And I'll explain why in just a second, why we were focused primarily on gender. And we had a debate about, and sorry, the technique we were using to do that is to say to each other that when we propose lists of arbitrator candidates to our clients, we would have a certain minimum number of women that we would include on the list. And the debate we had was, well, should that number be 50% or should that number be a different number, right? And there was a strong constituency for 50%, right? 50% is roughly, the world is 50% female, why shouldn't it be 50%? And we ended up going with 40% and not 50%. And the reason for that was that 40%, believe it or not, is actually already materially more, based on the statistics I told you at the beginning, materially more than is already being achieved, which is more like 12 to 20%. So we were already doubling kind of the results we're achieving. We thought that was a good step. And because of the way decisions are made about how arbitrators are appointed, in that it is not always unilaterally the law firm's decision, right? It's not only counsel's decision, there's a party who has to weigh in. Sometimes there's a co-arbitrator who has a view on who goes on to a short list. We decided to be a little bit less ambitious than parity. But 40% was still felt in the arbitration space to be, doubling where we are. So it was felt to be an ambitious step. I personally would have been happier with 50%, but I thought 40% was better than 30, and a heck of a lot better than where we actually, as an industry, where we are in terms of representation on tribunals. And the reason we were focused only on gender is that it's actually quite difficult sometimes to thoughtfully monitor and be transparent about the diversity outcomes that you're achieving on metrics other than gender. So that's one of the challenges in other, I know we're talking about gender today, but anyway, I'll stop there. That's a lot of just reflections. But the one thing I will say, having looked at the UN final thoughts, is I know that this is a real call to action, this report, and it has the idea with the annexes and the thinking about best practices was to provide a bit of a toolkit. And I don't want to undercut that sense that there's more to do. But from where I sit, some of the numbers look pretty good. And I think the UN system really does have within it, particularly with its rights framework, the tools to really keep going and to really be an example for systems like international arbitration, who we are continually challenged as a decision-making framework to say, well, if international courts can have parity or closer to parity or have 40% or 60% female judges, why can we not sort this out in arbitration? So keep up the good work, keep putting the pressure on us, keep setting the bar higher, get to parity and beyond, and that will help us, hold my clients, my colleagues, and my own feet to the fire in terms of pushing towards parity in the context in which I work.
Thank you very much, Elise, for your reflections. I think it's very interesting, the comparison, because in fact, the discussion on gender parity permeates to the other international tribunals and international practice in general. And we have always thought that it was very important. It's actually reflected in the annex, the numbers in arbitration and what have been done. And also about the comments on qualifications. We hope that we will, I think we are working in human rights, in the human rights field, towards what you were describing. I think it's getting more and more complex for, for us, even if the arguments are still being made to argue that there are not enough qualified women, but we are not yet there. And I think that that's, as Ninke mentioned, there are a lot of things that we hear in the background on this particular aspect, but we hope that we will be moving along as part of this report towards also rejecting that notion from the discussion. I wanted to take the last few minutes that we have from the panel to discuss a few questions and give everybody the chance to reflect and to comment on the whole discussion. I think there are two areas where I think that we should focus. Number one is what's next. I think that we have questions here on how do we make the UN act. We have been claiming and making these claims for a long time. Should we demand? What else do we need to do? I think that that's some of the sense of the questions that we have here. And also a very interesting question from Alex, who knows. Muchísimas gracias, Alex, for being here. And she asked, one of the questions that is not necessarily debated in the report, but I guess that it's a question that comes up as part of the discussion on these issues, and the question is about intersectionality, and she asked if anybody could be interested in discussing the issue of intersectionality and the importance of that issue when we talk about women, and if there is a chance for other women. If we are defining woman or a woman as in a particular way, we should have also in mind that there is a wide, diverse group of women that probably that should be represented in this international body. So I'm going to give the chance to everybody to answer, either or both questions. I'm going to start from Elisabeth, if you want to say anything on this.
Yes. Thank you very much, Claudia, Alex, for this question. We had that discussion inside the advisory committee as well, and we need to make some concessions. I cannot say more at this moment, but it was very difficult to integrate an intersectional, a very powerful intersectional approach. I mean, the non-binary gender identities inside this report. That's why I think that this is a tool. This is not a starting point, because we have heard this morning about all the work that we have already done during these years. But this is a tool, a humble tool maybe, and we need to push this tool. And that's why, for instance, from my experience inside the Human Rights Council, I like a lot the role of the presidency of the Human Rights Council, and the report has some important recommendations regarding that. The president of the Human Rights Council should consider systematically informing the council about the efforts made to achieve gender parity in recommending candidates. I think this is a very important tool. I had some meetings with the former president, the ambassador of Austria, and now we have the ambassador of Fiji. I think that they are very strong women, maybe no adjectives, as Jarpa mentioned. They are two women, and I think that they have a lot of good good intentions, but also political will to push this agenda. So I think that now that what we need to do is to elaborate a roadmap to consider who is responsible for what, and at the end of the day to make a lot of efforts to remedy the overrepresentation of men in the United Nations human rights body. Thank you, Claudia.
Thank you, Elisabeth. Ninke, and of course, if you are, you have access to the questions. If there are any questions that you think you would like to address as well, please feel free to do it. I don't want to read them, so we don't, use the time wisely. So ahead, Ninke.
So in the interest of time, I just want to say thank you to all the participants, the attendees, and there's excellent questions in here. And I certainly feel like I have stuff to say about all of them, but I'm not going to. So one point that I saw come up in two of the responses was the question of the Me Too movement and sexual harassment charges and sort of how that's come to play in selection procedures. And I think that's an issue that we need to focus on and think about more. I've seen there's been the development of these questionnaires that people fill out when they apply for these positions, which is something that has recently been added in the ICC procedure and is also present in the Inter-American screening mechanism, where you get people to sort of affirm that they have not done anything which will bring disrepute to the organization. And there's sort of ways to subtly get at that. There's also discussions about having NGO inputs. And then there's always the question which came up with Elisabeth when we were both on the Inter-American system screening mechanism, the question of what do you do when you get an accusation? What's the due process? What do you do in those circumstances? So I think there's still a lot of thinking that needs to go into this question of how to handle these procedures. This isn't about necessarily the selection of women, although it could come up in the selection of women candidates as well. And then on the question of, what do we do? Like, do we demand? Do we negotiate? I think these are strategic choices that need to sort of depend on the specific context in which we're operating in. Sally Kenny wrote this book Gender and Justice, where she analyzed, how the number of federal district court judges in the US grew over time. And she talked about these strategic alliances between insiders and outsiders in the various administrations. And I think that's an important thing to consider. How do you have people within the system who can push forward an agenda, as well as people outside who push forward the agenda? And honestly, that's what we see with GQual and other NGOs that have pushed for and achieved change. Is you need people on the outside and the inside working together to achieve meaningful outcomes. Thank you. And again, it's such a pleasure to be with all of you here today. Thank you.
Thank you, Ninke. Jarpa?
Yeah, so I'm going to answer 4 questions in 3 minutes. And the first 2 are comments and build up maybe on Ninke's point. I think that it's important for us to involve men allies, and there are some good ones there. So as Ninke and all of you know, we women tend to say we don't want panels made of only men. And I personally make sure that I don't do the reverse, where it's all women. So I think for that reason, we are faulted on this panel for being all women, but it's good to be in the company of my sisters, don't get me wrong. So let's involve the men who are partners. Viviana laid good points about what can be done at the state level to ensure that the recommendations go on and are enforced. And those are very plausible. We also look at it from the grassroots level. What can we do? And I think one of them is the pipeline. There are women who need a mentoring, who need a training, who need a coaching to get them ready for the next generation. So let's do that. On the question of intersectionality, that's a very important one. On this panel, as I was coming, I was thinking to myself, the global system is patriarchal. And you will all agree with me that the global system is also racist and it's homophobic, and we can add on to that. So it's taken us a long time, and we are still in the fight to break global patriarchy. Now, let's make sure that in breaking it, we are doing it simultaneously. And I know that's a lot of work to pile on, but let's also make sure that as we're doing it, we are also breaking racism. Because I can tell you as a Black woman that I have to deal with that. And so if we're dealing with this issue, and the question was about Afro-descendant women, if we are looking at the GRULAC region, group of Latin America and Caribbean, are we involving the Caribbean women in that region in the voices and discussions? Are we involving the Afro-descendant women? Let's make sure that we are working hand in hand and not being selective. Lastly, to the point, the question that Judge Linzard put in there, I think it's yes for me. I'm not a judge, but I can say this freely from an academic perspective, and Judge Linzard would appreciate this because she's an academic too, that women who are also at the table should be vocal, maybe some level of strategy, but that they should be outspoken. And I think that I can speak that Judge Linzard does, that other women judges I have seen, Judge Alapini at the ICC is unapologetically someone who speaks on behalf of women. And so let's combine all these. Women have to be there, men have to be there. Let's make sure we're creating a strong pipeline, because there are women. If we search, we will find. So thank you all.
Thank you, Jarpa. Viviana?
Well, thank you. Thanks again for convening the discussion. I think that on the issue of intersectionality, I believe that if we're more deliberate about the processes, and we're more deliberate about who are the women, and that women are not all in the same situations and conditions, and that backgrounds matter and experiences matter, we can move forward more significantly, even with a report that is not focused primarily on intersectionality. In paragraph 18 of the report, there is a mention to the need of ensuring that there is an intersectional approach to gender discrimination, and I think that we have to keep that, and we have to check ourselves all the time to see how inclusive we are as women and men, but also understanding as always that women is just not one type of woman with one specific experience and race and gender identity, etc., etc. But I think it's a discussion that has to happen, and I think it needs to happen as well in terms of the different voices that can be brought to the discussions, and the need of having a diverse pool of men and women, but women specifically in the development of law and justice. I think in my experience in litigating before the Inter-American Commission and the Inter-American Court, women that had very distinct backgrounds and experiences have brought things that were pretty unique. And valuing that and also telling those stories is not only about having a rule, but it's also about having a community that learns from their own experiences and learns from what the different women have brought to the table, and that notices the ones that the voices that are not there. For example, in my context of over 25 years of litigating, there have been very few indigenous lawyers that have litigated internationally. And that in our context is pretty shocking, considering the impact on some of the most important issues of our generation. And racism is rampant in Latin America, and you can see that with Afro-descendants, men and women, in patterns of violence, but also in structural discrimination and exclusion. So I think that having the rosters as well of trying to get women out there and keeping I don't know, lists, pools of women with different experiences that are known to a community is something that JARPA has done with her scholarship. And I think Ninke has participated in one of the books on women judges. And I think that a lot more could be done. And that would go to solve some of the problems that Three Crowns has, and so many more in arbitration. Like, you could have this amazing roster of women. Sometimes women, not every woman that is a fantastic judge or attorney has devoted time to writing up their contributions to the law, and that also comes at an expense, because then women are less sometimes valued than the men that have done the same thing. And so I think that ensuring that there are rosters, a pipeline in a more deliberate way, also the coaching and the strengthening of the opening of horizons. We've had, I don't know, I'm not sure whether hundreds, but probably dozens of conversations with people saying, there are these positions coming up, and I think you could be a fantastic candidate. And people saying, do you think I could be a fantastic candidate? Am I too young? And I'm like, well, I don't know. You're 45. I think your age is pretty good. It sounds wonderful. Many men have been president at that age, and nobody says anything about the judges that have been judges at 45. I mean, you can be a judge and a rapporteur and this and that. And so I think there's a lot of also, supporting each other, in criticizing each other, saying, no, I don't think that position is for you. You're going to get bored, or you don't have the background, or you do blah, blah, but also encouraging each other, telling each other that you can. And so I think that on that, the report has some some language, which I think we need to work on. We need to work on from the spaces that we occupy to promote women, to visibilize those women and make sure that they are noticed and that their scholarship and that their contributions to the law are there. And then I do believe, Liz, you were talking about how, you have these parties, and I'm not sure that I understand everything or most things about arbitration, but when states are critical for making the decisions on who's going to be there, and when businesses are critical as well in making those decisions, I think having some of these discussions and policies set up at the local level make it a little bit less presentable that they would never choose a woman arbiter. So I think maybe some countries are a lost cause. I don't know, many of the Latin American countries have seemed like a lost cause for a long time, but there is room for improvement, and there are, and having a focus not on the UN, but locally, with working at the local level with governments and with businesses and with the law associations, I think is critical to actually have them change their policies and practices. They've done it with manners. Many governments, I don't know, feel that they have to have at least some women in their panels now. And they do it sometimes with higher courts. And isn't there a pledge? I remember when we did the GQual pledge, there was a pledge for arbitration as well that was inspired partially in the GQual pledge. And I think keeping that pledge active is a way of renewing the political commitment of different governments as well. And the fantastic women are there.
Well, Liz, that's an introduction for you to make your final comments. So I give you the floor.
Let me unmute myself. Yes, there is a pledge, and it has had good effect. It has really drawn attention to, and it was modeled on the GQual pledge, absolutely, to draw attention to calling on all of the actors in the system to commit to taking concrete steps to move the dial on equal representation in tribunals. So my final comment will be very much like what I said before, which is I think what this report shows is that there are tools and that there are frameworks for continuing to make progress in this important area. And it's been a real pleasure and an honor to be able to be a very small scribe, second assistant junior midwife to the process. And it's been our pleasure to do it. So happy to contribute, and we'll watch and happy to continue to contribute to this really important effort, because it's fundamentally a question of legitimacy, fairness, and getting everybody a seat at the table.
Well, we haven't had the time to answer all the questions, which means that we will have to continue discussing this matter soon to see how the recommendations of the report evolve. When we started the campaign in 2015, we thought that by this time we were being pretty much done with the job. We haven't, but I think it's very important that a number of these issues that everybody who is here has been discussing for many years is now in the report. And so as everybody said, this is a tool to work with. There are recommendations that could be addressed to the government, to the different bodies in the UN, and including, I think there are recommendations that can also benefit the other regional systems, including even go across to other international bodies that are not human rights bodies. So I think it's a lot of work to do. And I'm very glad that we had the discussion. I want to thank everybody, Elisabeth for doing the report, my colleagues, the academics who were involved in creating and developing the ideas that the report nurtured from. Of course, the Chico campaign, my colleagues from the Chico campaign, and Liz and the colleagues for 3 Crowns for joining efforts to make sure that we did this work all together. So the discussion is to be continued. So I hope that we will have the chance to continue this conversation in the future. I want to thank the sponsoring institutions, my colleagues Adriana Buenaventura Martinez, Sara Lusato, who did a lot of work in to make sure that this panel was put together, the colleagues from the Technology Office, and of course, Diego Rodriguez and the Academy for Human Rights for supporting all the efforts towards discussing this matter. I'll see you all soon, hopefully in person. Thank you very much for being here and staying with us, and thank you for the panelists as well. Take care. Bye.